that survivors actually receive the reparations awarded to them. So today, we're going to have an interregional exchange of experiences from litigators across the world who are going to share their strategies that they've employed before different regional and international human rights mechanisms to advance implementation. From the Inter-American Human Rights System, we welcome Alejandro Escobar Cortazar, a human rights lawyer and Masters of Law from the National University of Colombia. She's currently the coordinator of international litigation at the Jose Alvear Restrepo Lawyers Collective, CAJAR, where she represents victims of serious human rights violations before the Inter-American Human Rights System. She's extensive experience supporting social, women's, indigenous and trade union organizations, both through strategic litigation before the Inter-American Commission and Court of Human Rights, and through engagement with monitoring and protection mechanisms, including precautionary and provisional measures. From the African Human Rights System, we welcome Michael Gaya-Nyarko, the Deputy Executive Director of the Institute for Human Rights and Development in Africa, IHRDA. His work focuses on legal advocacy, capacity building, research, and strengthening African human rights bodies. He's represented victims before all 3 African Union human rights mechanisms and has been closely involved in strategizing and building partnerships to advance implementation. And prior to joining IHRDA, he served as manager of the Litigation and Implementation Unit at the Centre for Human Rights of the University of Pretoria, where he spent a decade engaged in research, advocacy, capacity building, and litigation. From the European Human Rights System, we welcome Dr. Ramute Remasaita, a human rights lawyer and scholar specialising in implementation of European Court of Human Rights judgments. She's the Vice Chair and Board Member of the European Implementation Network and is Senior Legal Consultant and Implementation Lead with the European Human Rights Advocacy Centre, ERAC, and supporting strategic litigation and advocacy before the Council of Europe. Her research and advocacy focus on state compliance with human rights standards, particularly in Eastern Europe and the Caucasus. And in 2024, she authored Compliance with Judgments of the European Court of Human Rights, States on a Spectrum of Democratization with BRIL, which provides a groundbreaking analysis of partial compliance and the broader impact of ECHR rulings. And from the United Nations system, we welcome Selina Kafle, Executive Director of the Human Rights and Justice Centre in Nepal. She leads efforts to advance accountability and transitional justice with gross human rights violations and has represented victims in landmark cases before UN human rights mechanism and plays a leading role in advocating for and strategizing on effective implementation of their decisions at the national level. So thank you so much to our speakers for accepting this invitation and sharing their extensive experiences. So to open up this panel discussion, I'm going to pose 2 questions to each speaker. First of all, there'll be an individual question for you to respond to, and then I'll come back and have a general question for all the panelists, and you have 5 minutes each to respond. So the first question, question 1 for Alejandra, is ongoing armed conflicts are often identified as one of the main contextual obstacles to the implementation of human rights decisions. CAJAR has litigated cases before the Inter-American Human Rights System for more than 30 years. How has the implementation process unfolded in the context of Colombia's ongoing conflict? And what strategies or tactics has CAJAR deployed to advance the implementation of decisions in such a challenging context? Alejandra, over to you.
Bueno, muy buenos días, tardes o noches para todos, todas y todes. Muchas gracias por participar de este webinar y de nuevo agradecer a los y las organizadoras por esta invitación. Creo que a fin de atender esta pregunta me gustaría dividir mi respuesta en 2 niveles que transcurren en el marco del litigio estratégico y la implementación o cumplimiento de las decisiones en sí mismas. Efectivamente, a partir de 1995, Colombia ha sido condenada por su responsabilidad internacional en 33 oportunidades por parte de la Corte Interamericana de Derechos Humanos. Si bien las temáticas que han sido abordadas en estas decisiones son muy diversas, la mayor parte de los casos efectivamente se relaciona con la violencia social y política y el conflicto armado que ha afrontado de manera persistente el país durante más de 6 décadas. Así, creo que un primer nivel sería esta pregunta y es, ¿qué esperamos de las órdenes del Tribunal Interamericano? Y es que jurisprudencialmente la Corte Interamericana ha consolidado estándares y criterios de reparación integral que van mucho más allá de la justa indemnización o la restitución, que son los conceptos base establecidos en el artículo 63 de la Convención Americana sobre Derechos Humanos, el cual trata sobre la obligación de reparar el ilícito internacional. En efecto, hoy además de ese alivio de la situación individual, las órdenes de la Corte tienen un enfoque transformador de los contextos de violencia estructural. Señalo que esto es un primer nivel justamente porque es en esa fase litigiosa o contenciosa cuando como representantes y víctimas presentamos o proponemos a la Corte las medidas que deberían ser ordenadas, adoptadas a fin de transformar el contexto y garantizar la no repetición de las vulneraciones. Este enfoque de transformación se ha consolidado hoy a través de la disposición de garantías de no repetición, adecuación normativa y el impulso de modificaciones a, a las prácticas estatales. Resalto además este planteamiento porque considero que como representantes o víctimas que acudimos ante tribunales internacionales no somos agentes pasivos en la determinación de medidas adecuadas, sino verdaderamente agentes de cambio que a través de un caso particular buscamos se establezcan mejores y mayores garantías para el ejercicio de derechos y libertades convencionalmente protegidos. Ahora, ya en un segundo nivel, a veces creo que es muy sencillo caer en el pesimismo o la desesperanza de la falta de cumplimiento de las órdenes dispuestas en las sentencias. Como les mencionaba, Colombia ha sido condenada en 33 oportunidades entre 1995 y 2024. Sin embargo, hasta hoy solamente un caso ha sido archivado por cumplimiento total de las disposiciones, el caso Ángel Duque contra Colombia. Todas las demás decisiones permanecen en seguimiento de una o varias medidas. En general, justamente de las de más difícil cumplimiento, como la investigación o la búsqueda de las personas desaparecidas, pero también aquellas que tienen un mayor costo político o que involucran adecuaciones normativas o cambios estructurales, que en el fondo es lo que buscamos, ¿no? Entonces, la estrategia, me permito afirmar, es la que siempre hemos utilizado como movimiento de defensa de derechos humanos, tratándose de evitar que esas decisiones judiciales tan importantes se conviertan en letra muerta. Esto es insistir y replicar. Insistir supone evitar que las decisiones de la Corte caigan en el país del olvido o sean engavetadas en los anaqueles de la historia. Todas y cada una de las decisiones debe ser cumplida en los plazos y bajo los estándares definidos por el tribunal. Esto lo hacemos procurando espacios de concertación al más alto nivel, pero también manteniendo en la agenda pública la discusión, no solo de la necesidad de dar cumplimiento a esas órdenes, sino de los impactos favorables de la implementación de estas medidas para la superación del conflicto armado y del contexto de violencia sociopolítica. No es sencillo, nunca lo es, pero hacer del cumplimiento de estas decisiones una preocupación social es necesario, puesto que favorece que otros actores sociales se sumen a la reivindicación, incluso desde las distintas ramas del poder público, como el legislativo, el judicial, el ejecutivo. En ese insistir, fundamental el seguimiento que realiza la Corte de sus propias decisiones. Como representantes, tenemos que mantener al tribunal informado sobre los obstáculos que subsisten para el cumplimiento de las medidas, incluso buscando espacios como audiencias de supervisión, de forma tal que la Corte pueda adoptar resoluciones que conminen o insistan en el cumplimiento, facilitando la superación de las discusiones que, por supuesto, nunca son ajenas a los procesos de concertación para la implementación y también brindando al Estado las herramientas y los lineamientos que puedan o que más bien permitan superar esos obstáculos que han sido identificados. Entonces, esa supervisión cercana y permanente de la Corte es la mejor garantía de cumplimiento. Un ejemplo de ello es el caso de la masacre de Mapiripán contra Colombia. Ya desde su decisión, el tribunal ordenó y definió el establecimiento de un mecanismo conjunto de seguimiento, si se quiere tripartito, Estado, representantes, Corte, que tenía una duración de aproximadamente 3 años, si no me equivoco, y que, digamos, durante su funcionamiento, durante su vigencia, permitió unos enormes avances en los primeros años posteriores a la decisión. Una vez finalizó este mecanismo, el proceso de concertación e implementación se vio estancado. Entonces, ya de por sí, la implementación de este tipo de mecanismos es una buena práctica que debería poderse replicar también en otras decisiones. Ahora, también le señalaba que es necesario replicar. En Colombia, los tratados de derechos humanos ratificados por el país adoptan rango constitucional y por esa vía del bloque de constitucionalidad, su observancia es de obligatorio cumplimiento para funcionarios y funcionarios estatales, especialmente tribunales internos, mediante el control de convencionalidad. Además, como intérprete legítima de la Convención Americana sobre Derechos Humanos, las decisiones de la Corte Interamericana van a seguir este mismo destino, es decir, son obligatorias y tendrán rango constitucional. Así, a través del litigio ante instancias internas y de la incidencia para la observancia de los derechos humanos, las organizaciones representantes de víctimas lo que hemos procurado es adelantar no solo recursos internos para culminar el cumplimiento, sino replicar en el ordenamiento a través de otros casos los avances en materia de derechos humanos alcanzados por la Corte Interamericana. Esta obligatoriedad de la aplicación de estándares interamericanos ha brindado fruto. Por ejemplo, las decisiones de nuestra Corte Constitucional sobre la incompetencia absoluta de la jurisdicción penal militar para conocer sobre vulneraciones a derechos humanos, la Directiva Presidencial 07 de diciembre de 2023 sobre la garantía para la labor de personas defensoras y la disposición de medidas de reparación integral en sus 5 dimensiones, que es hoy una jurisprudencia pacífica del Consejo de Estado. Bueno, espero haber dado respuesta a la pregunta. Muchísimas gracias.
Thank you so much, Alejandra. I think that's a great start, and I think stresses the need for tenacity, and that these decisions are not single entities, that they can have much broader influence beyond just the single decision as well. So thank you so much. So I'm going to come now to Selina Kafle. And the question for you is, most of the decisions adopted by the UN Human Rights Committee in relation to Nepal concern armed conflict cases and include recommendations for legal reforms to address the root causes of violations. And Nepal is currently undergoing a transitional justice process, recently approved by the government. How have attempts to implement these decisions influenced the transitional justice process? And how have practitioners sought to bring the implementation debate into this transition context? Over to you, Selina.
Thank you, Rachel. Thank you, REDRESS, for this opportunity. Nepal's journey of transitional justice since the end of conflict in 2006 has been very complex and very turbulent. The Nepal adopted a law in 2014, and like you said, recently revised it. However, there are still concerns that the revised law is not in line with international standards fully. In this landscape, I would say that UN Human Rights Committee has played a very significant role. Also, for the fact that Nepal does not have any regional in human rights mechanisms, and the cases that were there were not did not meet the criteria to be taken to International Criminal Court. So, in these vacuum, I think Human Rights Committee has absolutely played its role in recognizing the victims and also providing laws on effective remedy, I would say. Since 2008, there are 23 decisions concerning Nepal's conflict cases, and we can see that these cases, the recommendations, or let's say decision of the Human Rights Committee, initially started with recommending investigation and prosecution, while later on also adopted different forms of reparation in the forms of rehabilitation and satisfaction to the victims. So it seems that in Nepal, all of these recommendations have been quite visible, and that can also be said for the fact that when Nepal revised its National Penal Code in 2018, some of these changes were made in line with Human Rights Committee's decisions. For instance, there were a lot of cases of enforced disappearance before the committee, and Nepal's laws criminalized enforced disappearances and torture in 2018. There were also revisions in the statute of limitation on sexual violence cases. Now, these changes do not fully encapsulate the international standards, but I would say that there are still tangible progresses that were made afterwards. Um, Also, I think in more broad terms, also Nepal's transitional justice trajectory has been inspired by Human Rights Committee's decisions, for the fact that when Nepal was revising the laws in 2022, many civil society organizations and victims got together, and all of these were put forward in the national consultations that was held by Ministry of Law. And after these, reparation was recognized as a right of the victim in Nepal's law, which I think is a very progressive law in context of Nepal, which did not encapsulated the vision of reparation quite fully earlier. And there was also opening space for the victims of sexual violence to relodge their complaints. So I would say that all these have been somewhat has been influenced by Human Rights Committee's decisions. Like I said, that there are still victims and organizations who feel that all of these do not meet into international criteria. And I would say that also gets somewhat inspired by the decision of the Human Rights Committee, because it says that for gross human rights violations like torture and enforced disappearances, commissions like transitional justice commissions that we have, like truth and reconciliation commissions, are not enough, and they should go through the criminal prosecution. So this itself, the voices that are raised by victims and civil society organizations, somewhat reflect what Human Rights Committee said earlier. And I would say that civil society organizations have woven their advocacy efforts through the decisions of Human Rights Committee, and this has happened through several platforms. For instance, while writing reports to the Universal Periodic Review, or through consultations, like I said, on law reform. Every time these decisions are quoted by the civil society organizations, for different kind of measures have been adopted by civil society organizations, like holding meetings with the executive officers who are in place of implementing these decisions, as this is again states responsibility. And we've also in the past held different meetings at the local level with local government on recommendations of reparation, so that it gets more easily quick and done quickly, and I can come to discuss more on that in the second question as well. But I would say that Nepal has quite richly engaged in other UN human rights mechanisms, like special procedures, like I said, Universal Periodic Review, and utilized various parallel tools to voice the opinions said by the UN Human Rights Committee, as well as other factors in the national mechanisms. One last thing I'd like to raise on what we did as a coalition of CSOs here in Nepal is that we do not have a specific body to overlook and monitor all the decisions of the international bodies in Nepal. And that was a vacuum that played a big role. It was a big challenge for victims, because there were many ministries to go through, and it was very difficult not to have this coordination level body. So a public interest litigation was filed before the Supreme Court of Nepal, and we've asked the court to direct the government to have a national mechanism to look into these matters, so that the implementation happens more effectively. The case is still in progress, and we've not heard more. We still need to see how it unfolds. But nevertheless, I think that's one of the best practices that we have tried to adopt. Apart from that, there are websites like realrightsnow.com that Redress, Human Rights and Justice Center Advocacy Forum have collected collectively built in to disseminate more information about the cases to the larger platforms. There are government officers who are unaware about Human Rights Committee, its capacity, and state obligations coming from it. So there are multiple meetings on it. We also did one meeting with one of the members of the Human Rights Committee to give it more visibility. So all these steps have been taken from our side to give all these decisions more life, I would say. Thank you.
Thank you so much, Selina, for a very positive sort of set of examples, and I think illustrates and goes back to Alejandra's point about keeping these decisions alive and using opportunities at the domestic and international level to raise them again and to integrate them into other processes. So thank you so much, Selina. So I'm going to move now to Michael, and the question for Michael is, IHRDA has litigated some of the most emblematic cases in the African Commission and Court against various states. However, implementation within this system continues to raise some concerns as it's not clear what the procedure is for follow-up of decisions. What strategies has IHRDA and its partners employed to encourage a more proactive role by the African Commission and more broadly to promote effective implementation of those decisions by states? Over to you, Michael.
No, thank you very much, Rachel, for that question. I think the challenges seem to be common across regions. The question of implementation continues to be a significant challenge within the African human rights system as well. The system itself is designed to allocate the function of follow-up and implementation to the political policy organs within the African Union. The Executive Council is a designated body that is supposed to follow up with the member states to ensure that they constantly update and implement fully the recommendations or judgments that are given by the committee, the court, the commission. But the practice has shown that there is very little appetite within the policy organs to actually follow up and take this mandate seriously. So as you indicated in your introductory remarks, many of the human rights mechanisms have resolved to what some academics have referred to as self-help initiatives, such as these implementation follow-up hearings that are designed to provide an avenue where state parties would then come back to the mechanism to provide an update on what exactly the measures they have taken to implement the recommendations or decisions that they have been given by the mechanisms. And these cut across all the regional human rights mechanisms. On our part, we have adopted a number of strategies on following up and implementation. I'll just share two of those strategies because of time. We recognize perhaps first the lack of structure within some of the human rights mechanisms themselves in having accurate records of decisions that they have made over the decades, but also having tracking accurately what is the nature of reparations that were ordered and whether there is any information at all that these decisions may have been implemented. So there's not really any sort of consistent follow-up activities by the mechanisms themselves, asking member states, the litigants, and perhaps national human rights institutions that may have the information to update them so that they can also update their records. So within the African Commission, we have supported the African Commission with human resource capacity to put in place an implementation unit, which essentially is in the process of conducting a baseline assessment of all the decisions that the Commission has made over the past 30 years of its existence to set out what was the nature of the recommendations that were made to the specific member states that were respondents in the cases. And then that would provide sort of a starting point where you can accurately say that in all of these decisions, these are the number of recommendations that they have been made. And it provides the Commission then with a structured approach to be able to follow up directly with the state parties, with the litigants. And because the African Commission maintains a sort of affiliation status with 47 national human rights institutions across the continent, to also be able to follow up with those national human rights mechanisms for information, because oftentimes we assume that the recommendations are not being implemented. But in reality, many times it's because there's no information that the Commission has received from the litigants or other parties who may actually have information. So we think it's critically important that there exists that kind of formalized structure within the Commission to ensure that there is constant tracking and there's avenue for the Commission to be able to follow up. Internally, as an institution, we're also convinced that one of the ways to ensure effective implementation is to make it an issue at the national level, so that not only the litigants are interested in implementation of decisions, because many of the decisions have broader implications for national populations, especially where they relate to law, policy, or institutional reform, or oftentimes harmful practices that affects not just the individuals or communities that may be the litigants before the mechanisms, so that we cannot just make this an obligation of those who have litigated to be following up on the implementation of these decisions. So one of the initiatives that we came up with was what we designated as implementation dialogues, where we go to specific countries where we have litigated against the state party, select a number of cases, and have a national dialogue, bringing together the litigants, victims, national human rights institutions, other national CSOs who have the capacity to follow up, and the state parties' representatives themselves, and oftentimes officials from the human rights mechanism. So if the decision, for instance, relates to the African Commission, we would like to have one of the commissioners or someone from the Secretariat be present in these dialogues, so that together we can talk through what exactly is the current status of implementation, to ask about the challenges that the state party is facing in implementing these decisions, and perhaps also to find out how we as organizations that litigate before these mechanisms may be able to provide some technical assistance, because there are instances where you have issues of law reform or policy reform, and some state parties don't actually have the capacity to engage comprehensively in these kind of initiatives. So we also want to understand how we may be able to be of assistance beyond just being perceived as the adversary who is litigating against the state party. Because in essence, we litigate because we are interested in societies that are democratic, that value rule of law, and are inclusive, and ensure that everyone's right is protected. So we don't want to only be perceived as the adversary. Of course, if we have to be adversarial, we will take that step. But we want to also offer our own services to the relevant state parties, if there is any way we can build capacity of, say, the police or other actors who may be involved in excessive use of force, or to provide support for legislative drafting or other kinds of policy development. And that so also is designed to ensure that this becomes a national conversation that actors beyond the litigants are interested in, because the decisions have broader implications. And in May this year, we brought together, we've done these implementation dialogues in 7 countries, in Guinea, Mali, Malawi, Niger, Nigeria, and Sierra Leone. And in May, we brought together participants from all the 7 countries as sort of a platform for inter-country and inter-mechanism learning. We also brought the mechanisms themselves, the African courts, the Commission, the Committee of Experts, the ECOWAS Court, and the East African Court of Justice into this sort of dialogue, so that we talk through what strategies have been adopted, which ones are working. I mean, we've seen constitutional change in Malawi, for instance, to increase the age of the child from 16 to 18 years following litigation that we did against the state that was settled amicably. So we wanted to provide that platform so that the state parties can also learn from what other states are adopting as measures, but the civil society actors and the mechanisms can also learn from what are the innovative mechanisms that are being adopted, and to talk through those that may also be challenging, and how the gathering can provide some kind of guidance. So those are the 2 sort of main strategies that we have adopted at the moment. There are more that I could share, but I think for the interest of time, I will leave it here, and I look forward to further engagement.
Thank you so much, Michael, and having sort of seen some of those national dialogues, they are truly excellent in terms of moving beyond a sort of adversarial process and bringing a whole range of stakeholders together to talk in very practical ways about how to implement some of these challenging decisions. And I think the other point about your presentation is that the challenges are not just things that states face, they're also the international bodies themselves, having those mechanisms and processes in places. And it also goes back to Selina's point about that national level coordination is sometimes lacking, but at the international level, regional level, that sort of coordination across all of their different mechanisms, how they capture this information, is not always there. So thank you very much for raising those points. So I'm now going to come to Ramute. And the question for you is, the European system appears to have a much more structured follow-up procedure, particularly through the establishment of the Committee of Ministers. However, there are significant gaps in the implementation of decisions, especially those that go beyond financial compensation, such as release of imprisoned persons or guarantees of non-repetition, including legal reforms. So how has ERAC sought to address and overcome these implementation challenges? Over to you.
Thank you, Rachel, for this very important question. And also thank you to REDRESS for the opportunity to join this discussion on the ever-timely question of implementation. I'll be very happy to share some of the ERAC's experience in seeking to secure implementation of the judgments in the European system. And before I do that, I would just like to know that I will primarily be drawing on ERAC's experience, and ERAC's implementation experience concerns cases that come from rather complex domestic contexts, politically and legally. We work with partner organizations in countries like Ukraine, Georgia, Armenia, Azerbaijan. We also have a significant number of cases against Russia that is no longer part of the European system, the Council of Europe. And so, in other words, if you like, we work on some of the most difficult states in the European system, and the types of cases that we litigate and then that we try to address through implementation also concern deeply systemic structural issues, varying from enforced disappearances, excessive use of force by police and in prisons, gender-based violence, among others. So, which also makes implementation work very challenging. And I would also like to say a couple brief sentences on that European implementation mechanism, which makes the European system quite particular compared to other regional systems, in that there is this clear structure put in place where there is the Committee of Ministers, which is the highest political body of the Council of Europe, that is tasked to monitor and supervise the implementation. And there are procedures in place where states have an obligation to report on the progress on how they're implementing judgments. And what is particularly important for us as litigators is that applicants and NGOs and applicants' representatives have a right to make written submissions to the Committee of Ministers as a part of the supervision process, both with regard to the individual measures, what's known individual measures, or the individual situations of the victims, but also what's known as general measures, the systemic issues that I mentioned. So I would like to mention a couple points now on ERAC's efforts to address the challenges that we face. So firstly, I would name that we actively engage with that supervision mechanism. Although the states have an obligation to comply and engage with the Committee of Ministers, we also, in our experience, often see that this external pressure from litigators or applicants is necessary to ensure that there is sufficient attention put by the Committee of Ministers on the cases, on our cases, for example. We therefore put significant efforts in ensuring that the Committee of Ministers is constantly equipped with information as to what full implementation should look like beyond the monetary compensation, which normally is not a problematic issue in the European system. And we appreciate that the committee is tasked to supervise thousands of cases pending implementation, and so one written submission by an NGO may not be sufficient. So it really requires continuous sustained involvement and contribution by the litigators themselves. A second point that I would like to make is that the committee's supervision mechanism, the Council of Europe supervision mechanism, creates a channel to engage with the domestic authorities in the cases that we work on. Given that countries that we work in, we're limited in our ability to engage directly with the authorities, unlike what was really interesting to hear what Michael was saying about the dialogues being created which involve the authorities. So in some cases, there is no engagement at all with the authorities. So the supervision mechanism creates this channel for exchanges with the authorities, which is really significant. Very often we learn from their submissions, from the state submissions to the Committee of Ministers, what their plans are towards implementation, as they do not always report on it domestically. And even where they do, these are rather ad hoc situations, or in other words, NGOs and litigators have to work actively to pave the way for themselves to be involved in the implementation process domestically. And the last point to respond to this question, I would say, is the reliance on legally binding European Court judgments in broader advocacy. And that's something that we identified with time, is about using European Court judgments for broader advocacy on the very same issues that, say, domestic groups campaign on domestically that are addressed by the European Court judgments. What we have learned is that broader human rights advocacy groups do not always rely on the European Court judgments and are not even sometimes aware of the existence of those judgments and the findings of the court. So creating these synergies between litigators and human rights groups, broader human rights groups, ensure that legal obligations on the respondent states are raised in their public domestic campaigning, so that it's not only about political context, but it's also about legally binding obligations. I think I will stop here, just mindful of the time. I'll be happy to answer any questions.
Thank you so much. And all four of you have been absolutely perfect and keeping on time. So thank you. And I think the comments you just raised flag up issues around that sort of continuous and sustained involvement that's required in implementation, that once the decision has been adopted, it doesn't stop there. This could, this need to try and get aspects of the decision implemented can take many years, and the implications that has for litigants and victims and civil society, and so on, and the different ways. And I think it goes back to points that have been raised earlier about utilizing these decisions beyond those who may be immediately affected, and whether there are other avenues to that have implications, where these can be used. So before we move to the next round of questions for our panelists, we're going to take a moment to engage you directly through an interactive exercise, which is designed to reflect on some of the key obstacles and strategies and solutions in implementing human rights decisions across the different regions. You'll see 3 consecutive slides on the screen. I'm hoping that they will come up. I have no control over this, so there we go. With some questions, and translated into French, Arabic, Spanish, and Ukrainian. You have 1 minute to reply to each question that will appear, and you can type the answer in the language of your choice. To do that, we're using the Mentimeter tool. And to join this, either scan the QR code on the screen with your phone, or go to the link in the chat and type the code in on the screen. I'm hoping that is clear. Please do say if it's not, or put some query in the chat, and hopefully someone can help me help you navigate your way through that. So you have a minute to reply to each question. Thank you so much. Just tracking that and yeah, really interesting and some very common responses to those questions. So we're now going to go to a general question for all of our speakers. And then once we've heard their responses, we'll come over to the audience for some any questions that you might have. So the general question to all of our speakers is, what are the main lessons learned from your experience in promoting the implementation of human rights decisions, and how could these lessons inform future reforms of regional and international mechanisms to make enforcement more effective? So Alejandra, come to you first.
Muchas gracias. Bueno, siempre es un poco más difícil ir de primera, pero creo que no quisiera repetir algunos puntos que abordé previamente y que también los copanelistas han podido abordar, por lo que sí me quiero enfocar un poco más en lo que se refiere a unas buenas prácticas que hemos identificado en la Corte Interamericana y que podrían ser replicadas en otros sistemas regionales. Sí, está bien. Entonces, en general, como lecciones que hemos aprendido, lo señalaba hace un ratito, es insistir y replicar, mantener en la agenda pública el cumplimiento como un deber de Estado que no depende del vaivén, buscar alianzas en el movimiento social que faciliten la reivindicación y el impulso de modificaciones legislativas y el cambio de prácticas estatales. Me pareció muy interesante justamente lo que señalaba Ramute sobre cómo es fundamental difundir las decisiones que son también parte como de ese legado que existe y que desde las organizaciones deberíamos seguir reivindicándolas, compartiéndolas. E insistir también en la necesidad de la continua formación sobre derechos humanos. Em, no en pocas oportunidades en los procesos de supervisión vamos a poner a prueba nuestra creatividad, buscando, ofreciendo fórmulas factibles de cumplimiento o recurriendo a otros recursos legales para ese impulso. Sí, la voluntad política de cumplir va a ser la base y es la misma que llevó a nuestros estados a someterse a la competencia de los tribunales internacionales, pero para asegurar un cumplimiento acorde a esas necesidades de nuestros contextos es necesario adelantar espacios de concertación. Y aquí me parecía muy interesante justamente lo que señaló Michael en relación a los diálogos que se vienen adelantando, porque efectivamente es fundamental generar esos puentes con los tomadores o tomadoras de decisión y con los actores de las diferentes ramas del poder público. Ahora, como les mencionaba, la labor que adelanta la Corte Interamericana en la supervisión de sus decisiones es fundamental, pero es también una tarea titánica. A la fecha, la Corte Interamericana adelanta el seguimiento de un número plural de medidas ordenadas en 297 casos, digamos, cuyas sentencias han sido adoptadas hasta la fecha y que permanecen en supervisión de todo el continente. La magnitud de esa tarea pues lleva, por supuesto, unas dificultades monumentales, gigantescas, y esto lo menciono justamente para insistir en la importancia de fortalecer presupuestalmente y con todas las herramientas suficientes a los sistemas de protección regionales para que puedan ejercer ese mandato de manera integral. A pesar de las dificultades, es necesario pues señalar que la Corte ha maximizado sus recursos, adoptando medidas para garantizar un seguimiento cada vez más oportuno. Entre ellas, por ejemplo, la decisión de realizar una supervisión conjunta, más bien de orden temático, en relación a medidas que han sido ordenadas de manera similar en diferentes decisiones. En el caso de Colombia, la Corte realiza esta supervisión conjunta respecto de 9 casos en relación a la medida de tratamiento médico, psicológico y mental, y también una supervisión conjunta en relación a las medidas sobre búsqueda de personas desaparecidas. Otro punto es que desde la sociedad civil hemos valorado muy favorablemente la determinación de la Corte de establecer un equipo especializado al interior de la Secretaría Ejecutiva para hacer seguimiento a las decisiones interamericanas. Este establecimiento parece una medida sencilla o una medida que incluso es obvia, pero realmente tardó años en llegar y es una muy buena práctica que puede y debe replicarse, pero además fortalecerse, asegurando la sostenibilidad y la suficiencia presupuestal de este equipo al interior del tribunal. También desde hace unos años, entre periodos de sesiones, la Corte viene realizando visitas de supervisión a diferentes países de la región, como Colombia. Y durante estas visitas, además de realizar audiencias de supervisión en las que escucha el parecer de las partes sobre los avances del cumplimiento de las medidas y ofrece consideraciones y lineamientos para impulsar o facilitar el cumplimiento, la Corte realiza también reuniones con las entidades a cargo del cumplimiento de las medidas y esto pues permite facilitar un entendimiento de las órdenes, evaluar los mecanismos que hay al interior de los estados para ese cumplimiento. En algunos casos, además, el tribunal dispone de eventos académicos abiertos al público durante estas visitas, los cuales son realmente pues momentos en que se encuentra con la sociedad civil y que permiten difundir las decisiones y difundir el trabajo de la Corte. De esta manera, pues la Corte amplía su presencia regional, motiva un seguimiento mucho más cercano y, y puede tener también un mayor entendimiento de cuáles son esas dificultades persistentes para el cumplimiento, pero además se genera una supervisión, por supuesto, mucho más enfocada y acorde a los contextos nacionales. Otra buena práctica que hemos identificado, y esta ya es la última que quiero compartirles, es la realización por parte de la Corte de espacios de formación, como el curso sobre medidas de reparación y políticas públicas para su implementación, el cual está enfocado sí en actores de la sociedad civil, pero también en actores estatales. Estos procesos formativos, por supuesto, permiten fortalecer las capacidades de la sociedad civil para la exigencia y reivindicación, pero también le dan a estos tomadores y tomadoras de decisión y entidades ejecutoras herramientas para el cumplimiento. Hace un rato Salina mencionaba la necesidad también de que exista una estructura al interior de los estados para este cumplimiento. Me parece un punto fundamental. En el caso colombiano hay un equipo al interior de la Cancillería que se encarga de armonizar, si se quiere, el cumplimiento entre las diferentes entidades, pero desafortunadamente no tiene la fuerza suficiente para culminar. Entonces, coincido totalmente con lo que mencionaba Salina. Es muy importante que exista esa estructura al interior de los estados, pero además también es muy importante que esas entidades encargadas de armonizar o impulsar al interior de los estados tengan las herramientas suficientes para combinar realmente a otras entidades. Muchas gracias.
Thank you so much, Alejandra. And I think it reinforces that the decision on its own is never enough. Nothing is automatic, and that what's needed is a real multifaceted, multi-agency, multi-organization approach. So thank you so much for all of those examples. Selina, I'm going to come to you next.
Thank you, Rachel. I'm going to gather my experiences and share the lessons learned for Human Rights and Justice Center here in Nepal. The first one would be like working closely with the victims, because I feel that victims are the ones who keep the implementation alive. And what we've realized that when we empower the victims with knowledge, with legal processes, the decision-making bodies, all these help victims not only to feel symbolic victories, but I think it's also sustained it's a sustainable approach also, especially in Nepal's field of transitional justice, where there is less interest of the donor agencies and others in working in it, and there's been a huge reduction of funding for the organizations working in the in transitional justice areas. So I think that might be one of the experiences that I would like to share. The second one would be building stronger coalitions among the NGOs. I think this has come up again and again in our discussion as well, and in Nepal's context we have done it in few times, but I think we can do it more often, especially when there was consultation from the government. We all came together, pulled in our resources, funding, technical resources, capacities, and worked together as one big entity. It is also mostly required, especially in context of transitional justice, where political will is really lacking and it's very complex. So I think building coalitions would be my second experience. The third one would be systematic follow-up with the Human Rights Committee itself. From our experiences, whenever we submit reports and try to engage and communicate more with the members, it's kind of not only giving visibility to the cases, but also somewhat making the members see the faces that they render decisions on, and it makes them follow up more or work more. It's just a strategy we'd applied in the past of arranging the meeting of members with the victims that they rendered their decisions on. So I think a systematic follow-up with Human Rights Committee or to any other treaty body, I would say, would be really essential. The other one would be exploring multiple avenues, which we have discussed again and again already. So in Nepal's context, I think we have done that quite well with exploring all the available mechanisms. And fifth one would be prioritizing decisions in case of Human Rights Committee. For instance, I'd like to share that there are multiple categories of measures that Human Rights Committee has given Nepal, and I think likewise in some other context, is that it has measures on implementation, prosecution, and reparation. In Nepal's context, where political will for investigation and prosecution was really low, we tried to work on the measures of reparation first, prioritizing it first. Initially, with this big aim of having all the recommendations implemented, but when we realized that maybe a prioritization would help to achieve this more practically, we went with reparation. And then we also realized that reparations were more viable through local governments, and that's how in one of the cases on memorializing a victim of conflict and a minor who was extrajudicially killed, a memorial was built. We've started the memorialization. It's not fully complete, but at least the local government funded the memorialization process. So that also quite helped to have this measure implemented. And the last, I would say that working on at the stage of submitting complaints, making it more specific. I think this has also popped up in the discussion earlier. It was possible again in the same case to have it because it specifically mentioned that the victim's family wants memorialization for their son and as a form of satisfaction, and that's how we also could work around it when the decision actually came. So I think working at the stage of submitting complaints also is one of the areas I would say we can work on. Finally, I would say that a lot of things have come up on capacity building in our context, in Nepal's context of Human Rights Committee. I would say that the implementing actors, the government officers need to be more aware and they should have more capacity on dealing with this. So I think more can be done. That my whole presentation sounds positive, and it is positive somewhat, but there are also so many lacunas within the structure, and only a very few percentage of the measures have been implemented, while a lot still needs to be done. So I would say that all these measures might be helpful for the other context also to help it replicate in the national institutions. Thank you.
Thank you so much, Selina. And I think that point about keeping the victims at the forefront of the implementation discussion, whether that's at the national level or going back and engaging with the international bodies, and that sort of collective approach, that this isn't necessarily something that the litigants themselves can do. And I think the interesting point you make about prioritizing, some of these decisions have a long list of complex reparations, some much more complex than others, and trying to prioritize some that may be easier to generate some degree of goodwill is something that you can see across a range of systems. So thank you so much for those. Michael, over to you.
Yes, no, thank you very much, Rachel. I think a lot of the lessons have already been shared, but I mean, I agree perfectly with you that implementation doesn't often follow as a natural consequence of decisions, even though legally this is the expectation. So we must not assume that the state party will implement simply because the decision has been made. Oftentimes, the decisions don't even get to the national level. They get stuck in the Ministry of Foreign Affairs somewhere in their what you call it, capital in Addis Ababa or in Geneva or some other diplomatic mission abroad, and never gets to the national level. So we must make active follow-up an important part of our litigation strategy, so that we don't litigate, achieve what is significant legal victories, but then the actual benefits in terms of law reform, policy change, and practices do not emanate from those decisions. I think importantly, we must not assume lack of political will on the part of the states without first trying to engage, because sometimes there is significant lack of capacity within those states themselves. There are many ways in which engaging with the state parties could actually give us opportunities of how we can build the capacity of some relevant departments or agencies, but also to support measures that may enhance broader national reforms, whether it's policy reform, or even a civil society that is engaged in sensitization and awareness raising, that we can contribute to some of those efforts when there are harmful practices or other kinds of state agencies that are behaving badly, that we want to change such practices. So effective implementation requires deliberate and consistent follow-up to ensure that these things happen. I think it's important that we build partnerships beyond being adversarial, so that there are channels for communication, and we can actually follow up. Because as has been mentioned, there is not often structures that exist that you can easily go to and say, well, this is the individual or institution that we need to follow up with. Even within the ECOWAS, for instance, where the state parties are required to have so-called national focal points for implementation, the states often just designate the Attorney General as the focal point, and there's no structure or budget or mechanism in place to actually do the actual work once they receive a decision. So we need to find other innovative, informal ways of engaging, so that at least there are people that we can speak to within the state that may be able to speak to the decision makers. As my good friend Dr. Tarisai would usually say, that political will is sometimes a person. And if you don't know that person who you need to engage with, then you would say that the state does not have no political will. Meanwhile, it's one individual within the government who is the bottleneck, to this decision actually being implemented. So we need to find those ways of bridging some of the relationship gaps, and we can be adversaries, but at the core we agree that human rights are important. That's why the state parties ratify these treaties. We may disagree on what exactly is the manner in which they must be implemented, but at their core, we seem to have a common goal with the state parties, that the treaties are important, and therefore, once they ratify, they must follow through to implement those obligations. I think it is important to also continue to advocate for these formal structures of implementation that we have been talking about, so that we really have some formal process of following up at the national level, and it's not just a random ad hoc, kind of process. But for me, I think at its core, the biggest challenge is because there is no real legal framework for enforcement of the decisions of international regional human rights decisions at the national level. So we need to think through innovatively, how do we bridge this gap? We have seen this happen in other contexts, where, for instance, when it comes to foreign arbitral awards, the New York Convention exists to ensure that you could actually enforce those decisions, arbitral awards, at the national level in some way. Recently, we've seen the Hague Convention come into force in 2023, where civil and commercial awards from state parties can be enforced in other states. But when it comes to international human rights treaty bodies and regional courts, there seems to be a feigning of ignorance that state parties could actually have a structured approach where some of these decisions could be implemented through national courts. For instance, I know in my own home country, in Ghana, there has been attempts to implement ECOWAS court decisions through the national courts, which has been resisted because the court simply said, well, the ECOWAS treaty has not been domesticated, and therefore I have no legal basis for actually enforcing this decision. So we need to think through, how do we put together these kind of legal frameworks that enable us to have a proper structured way, perhaps even through the national courts, so that decisions have a formal avenue for enforcement. I know within the African context, the Pan-African Parliament is in the process of developing some sort of a model law on how state parties can ensure enforcement of the decisions that emanate from regional mechanisms. And those are some of the formal structural needs that we need to continue to talk about and to put in place so that these victims, actually receive the material and other benefits that emanate from decisions, and not just the symbolic win that the rights violations were declared by the human rights mechanisms. I think I'll stop there, Rachel.
Thank you so much, Michael, and also for mentioning the Pan-African Parliament's initiative and drafting the model law, which is in the process of being discussed as a useful tool for state authorities and others to think about in terms of the very practical, logistical, bureaucratic requirements when you receive a decision from an international body, whether it's binding or not. And I think your points go back to the importance of dialogue, which has come up at numerous stages already, and reiterating, I think, Selina's point here about the implementation starts with the drafting of the decision. I think often you think this is post-decision, something to think about when you get to that stage several years down the line, but actually it starts right at the very beginning in terms of the drafting of the decision. So thank you so much, Michael. And Ramute, over to you for your comment.
Yes, thank you, Rachel. As the last one to respond to the question, I can certainly see a lot of, from the earlier interventions, a lot of crossover as to the lessons learned and similarities that we all come across. So as a first lesson learned, I would like to say, and that can apply to any jurisdiction, not only the European jurisdiction, and it's particularly relevant, I think, to contexts where domestic implementation faces huge barriers, which is that acknowledgement of the individual victims suffering an injustice in the implementation process, not only the litigation process, can be as significant to them as the actual restoration of their rights and reparation. I think it builds on what Selina was saying about putting victims at the forefront. And many of the victims who we represent in our cases tell us that ensuring that their voices are heard and that the truth is established is as important to them as the sort of more conventional reparation measures being put in place. And this is particularly significant in cases and contexts like those that Iraq works in, where reparations go beyond compensation do not come soon after the judgment is adopted, or may not be even possible at all in certain political context, and the growing authoritarianism that we witness in the countries that we work in today. We have seen that with cases of human rights defenders and activists, for example, who were targeted for their legitimate human rights work and portrayed as, say, traitors and criminals to the public domestically, and they had no tools whatsoever domestically to defend themselves. So litigation and implementation is also about that, about making their voices heard. Another point, also a lesson that I wanted to share, and it's something that I already touched upon in my earlier intervention, I would like to build on, is again this need for sustained use of the available tools to advance implementation, not only by the civil society and litigators, but also in the European system. In the case of the European system, the supervision mechanism itself, the Committee of Ministers itself. And that's what we learned from our implementation work, is that although member states have this obligation to report to the Committee of Ministers on the progress, that is not enough in many cases where issues are deeply systemic and structural and politically insensitive. There is a need for the civil society groups to closely monitor that process and continuously push for that progress, not only on what should be done and providing recommendations, but also expose the failures, which can sometimes be seen as delays or failures by the states, which would require more time, but can also amount to resistance. And that's something that the civil society needs to be vocal about. And in the current times, we're also witnessing this growing disengagement from certain states that we work in, where the shift to the authoritarianism has been observed, which I think is another alarming point that we need to take into consideration. And so, for instance, for some cases, we continuously push for the cases to be kept on the Committee of Ministers' agenda to keep awareness of them, or otherwise they may not receive sufficient attention, and respondent member states may be sort of let off the hook on the very systemic issues that particularly where they remain very present today. We also often hear from domestic litigating NGOs that a lot of their efforts and resources go into litigation. But what we see is that implementation work requires as many resources and efforts from litigants and NGOs as litigation does for any change to happen, particularly on those, again, these very systemic issues that I mentioned before. Also, for what we learned as an important lesson is that for more reluctant states or resistant states, the Committee of Ministers monitoring mechanism is also a tool for the documentation of violations, which is in itself is significant. It works as a public documentation hub, as it runs a database containing all the information provided by the parties concerned. And now one more point on the Committee of Ministers itself. Also, the supervision process is both legal in that it reviews the compliance with legally binding judgments, but it's also political, as the Committee of Ministers consists of political representatives from their home countries, from the member states. And so in some cases, other actors, such as economic or geopolitical ones, come into play and place huge challenges to the implementation process. In some instances, the civil society really needs to step in and advocate strongly, not only with the Committee of Ministers vis-a-vis the respondent states, but also the Committee of Ministers itself to take a firmer, stronger stance in certain cases. As an example, the Committee of Ministers has tools in place to address situations where there is a persistent failure by a state when the case, for example, such as in what's known as infringement proceedings, when the case goes back to the court for it to establish if the state refuses to comply with the judgment. And the committee has so far it has been used only a couple of times so far, and the Committee of Ministers has been quite reserved in using it in other instances. Now, a couple more brief points on how this can inform any future reforms for the European system and beyond. So the Council of Europe supervision system is primarily based on goodwill and dialogue, but less so to address the non-execution as the growing issue in Europe today as well. And one big question today is if the European system, as it is now, is equipped to deal with the growing authoritarianism in some of its member states, which then in turn seriously undermines such states' obligation to comply with their European Court judgments. It becomes no longer about non-implementation on one particular judgment, but is a much bigger question of abiding with the international obligations. And I would like to refer to this one metaphor that I like very much that was made by Judge Pavli of the European Court, who essentially questioned if the court should deal with individual burning trees when the whole forest is on fire. And I think the same applies to the implementation process and the Committee of Ministers with regard to some member states in the Council of Europe. And one very last point, as a suggestion that we are exploring increasingly at IRAC, is this idea for an interaction and exchange of information and expertise between international and regional mechanisms addressing the same systemic issues against the same states. I think should be encouraged. IRAC has put quite a significant effort into exploring that with regard to the European Court judgments and the decisions of the working group on enforced disappearances from the UN, and which was very well welcomed by the European mechanism, in that there is the interplay created could be quite significant in advancing the implementation matters. Thank you.
Thank you so much, Ramiti, for all those really valuable comments. And I think that issue about implementation is very resource heavy. And, you know, the ability of litigants and civil society organizations to have that long sustained engagement and the costs and the funding may not be available to do that, I think is a big challenge. but the need for therefore coordinated response in drawing on a whole range of different actors, maybe not the usual suspects, is clearly important, and that's something that you've just flagged up. So thank you for all our 4 speakers. We now have a bit of time. We have 10 minutes left for some questions. I see a couple in the chat, which I'm just going to read out. The first one from Laura Stella. Hello, Laura. So thank you to the panelists. Wondering whether the panelists have experience of inter-regional NGO collaboration in this area and their assessment of impact, and if no experience, is this a potentially viable avenue to enhance enforcement? And I think that's exactly the final point that you were trying to also raise as well, Ramute. So that's for everybody. I'll come back to you all shortly. Then we have an additional question from Isabella, and this is to Michael. Kenya was given a 3-month deadline from November 2024 to file a report on the measures it's taken to implement the judgment issued in 2017 by the African Court via application number 006/2012, which is the Ogiek case, African Commission against the Republic of Kenya. And there's been no movement since. Has your team considered Kenya for dialogues? Do you think that would help? And then I think there's a couple of questions in the Q&A. Charlotte, Human Rights Advisor at the World Organization Against Torture. Following up from Selina's intervention, like to know which legal grounds did you submit your public interest litigation to request the Nepalese state to establish a national mechanism in charge of implementing decisions? And also like to know, in your opinion, how to ensure effective implementation of a UN treaty body decision when the state, and in that case Burundi, refuses any kind of cooperation with CSOs, international mechanisms, or the lawyers who submitted the case and have been in forced exile for a decade and can't engage with national jurisdictions. And then Lydia, are there innovative strategies or recommendations that could be strengthened or crafted to ensure follow-up on implementation of gender-related decisions? So I'm going to do it in reverse order so that Alejandra doesn't have to go first again. So I'm going to come to Ramute first. I'm just looking at the time. If you just have a couple of minutes for responding to any of those questions. Over to you.
Thank you, Rachel. So on this question of the idea for interregional NGO experience, NGO collaboration. So I've already mentioned this idea of us and as an NGO encouraging some collaboration among the regional human rights institutions. When it comes to the NGO collaboration, I would say we have less experience for interregional collaboration, but we very much encourage and favor collaboration within the European system. We do, in general, our working as a working method of ERAC, we do work in coalitions, we do work in partnerships, primarily with organizations in the countries on the ground, so that we cover both the supervision process on the European level, but we also put all the efforts that can be done domestically. I would be very interested to explore this idea of the interregional NGO collaboration as well as, and I think as this discussion today has shown, there are many crossovers and ideas that that can be even more lessons learned from the various experiences that we have. So I think a short answer would be certainly worth exploring.
Thank you so much. Michael, I'm going to come to you next.
Yes, thank you, Rachel. I think certainly worth exploring. I think I have seen much more collaboration within academia with research institutions. I know when I was in Pretoria, we did a bit of work with Bristol, for instance, trying to find out the status of implementation and documenting that in academic research and all of that. But in terms of the practical day-to-day kind of interactions, they might be, much less frequent, and perhaps this could be an opportunity to, formalize that kind of engagement, because there's a lot more that we can learn from each other and to borrow a leaf here and there. So definitely, we've putting ideas together on how we could benefit from such interregional conversations. There was a question that was directed at me with regards to Kenya. I think Kenya actually was the first country that we piloted this country dialogues, and we started with this Nubian children's case, which is a situation of statelessness for children of Nubian descent in Kenya who at independence were denied citizenship because, according to the government, they had no homeland per se within Kenya, even though they had been in Kenya for about a century or more. Most of them moving from Sudan into Kenya at some point. But that's where we started piloting this project from. So we have done some engagement in Kenya. The Ogiek case that is being referenced, perhaps the clarity I should have provided earlier was the dialogues only related to the cases that we litigated, because we were interested in following up on the cases that we litigated and to be able to ensure that the victims represented actually get the benefits from those recommendations or decisions. So we have not done any on the Ogiek case yet. It's an ongoing, evolving situation, and we definitely are paying attention. We know the African Court itself has been asking the Kenyan government to come back and report. So we keep a close eye, and we hope that at some point we may be able to do something in that regard as well.
Thank you, Michael. And just on the Ogiek case, because I've an amicus that with Pretoria Centre as well, there was a compliance hearing earlier on this year where I think the court is trying, as Michael said, very much trying to question the state in detail about what it has done and having that sort of dialogue with it. What happens next? It will be interesting in terms of what steps the court's going to take and how much further engagement is going to have, but that is certainly ongoing. So thank you so much, Michael. Selina, any final comments and responses from you?
Yeah, thank you. I think I'd like to respond to a question that was directed at me. I think the general questions have already been answered regarding the public interest litigation that was taken before Supreme Court of Nepal. The Constitution of Nepal provides Supreme Court with an extraordinary jurisdiction in Nepal's case where people can bring up the cases of public concerns. So we had to show that these all are public concerns. Nepal also has laws where it has provisions to say that the treaties and the provisions that Nepal has ratified has a superior value than the domestic ones, although it is not so in implementation, only in letters, but at least we channelize and use these letters and commitments of Nepal government to lodge the petition. We also based our on our petition on the international treaties that Nepal signed on and other practices and other tools that have been used so far in so far. We also tried to explore if we could get one of the HRC members as amicus curiae. That was not so possible in Nepal's context, and then we thought that maybe the member could write could put in some legal arguments for the lawyers to plead on the case, but that did not materialized well enough because of various reasons. But we also explored that, and I would say that it's very much based on Nepal's laws and international commitments through treaties. About my opinion on how to ensure effective implementation in Burundi's case, I don't know if I might be the right person to answer this, but maybe I would just share my experiences, maybe something that comes to my head when you ask this, that maybe engaging with several UN bodies can be one of the strategies, such as special rapporteurs or others. Maybe regional bodies such as African Union or others might also come into play to give it a more traction. Also, maybe diplomatic pressure can be helpful. Identify the states who might be sympathetic towards the country and the issues and try to work with them towards pushing the government more onto that area. Maybe I remember that Ramute focused on documentation, so maybe at least try to document the cases, maybe using different labels as rule of law or human rights in general, if specific words are more difficult in the context that you're talking about. Using international media might be other strategy, and these are all coming up on my head. I don't know if this would fit entirely into your context or not, but maybe also using diaspora-led advocacy for the ones who have been exiled, and broader awareness, I would say, through international media, again, maybe dialogues within the country in different labels, like I said, rule of law, human rights, or whatever suits better to the government, to the ears of the government. These are all that comes up in my head. Thank you for the question, and I hope I was able to answer it.
Thank you so much, Selena. Absolutely. And Alejandra, over to you.
Vale, muchas gracias. Para ser respetuoso del tiempo, porque sé que estamos un poco tarde, voy a hacer muy rápidamente. Creo que puedo aportar en dos de las preguntas. La primera, creo que este webinar es un gran ejemplo justamente de la importancia de estos diálogos interregionales. La verdad, me voy con un montón de ideas. Creo que conocer esas experiencias y también esas iniciativas ayuda a no caer en la desesperanza, sino también a esa creatividad que nos debe mover en esta labor, que también es muy difícil después del litigio, que es justamente asegurar que las sentencias se cumplen. Ahora, en relación a la implementación de decisiones con un enfoque diferencial de género, creo que se suma la dificultad. A las dificultades que hoy hemos hablado, que hemos conversado, está la dificultad adicional de la persistencia y permanencia de estereotipos de género y de prejuicios de género que dificultan justamente ese cumplimiento. Entonces, creo que temas básicos, lo primero es asegurar la centralidad de las víctimas en la implementación, que ninguna decisión sea tomada sin su consentimiento, pero también sus aportes, que también a estas discusiones se puedan incorporar las organizaciones de mujeres que no solamente han litigado muchísimos casos, sino que han participado abiertamente en las calles, justamente las reivindicaciones que esperamos terminan también siendo reivindicadas en estas decisiones con posterioridad, y asegurar también una formación continua de los tomadoras de decisión y entidades encargadas de la implementación a fin de asegurar justamente la superación de prejuicios que son muchas veces los que evitan que las decisiones puedan ser cumplidas. Muchas gracias.
Thank you so much, Alejandra. So I realise we have gone a few minutes over time. So just to conclude this discussion and just sincerely thank Alejandra, Selena, Michael, and Ramute for sharing their really invaluable insights and experiences. And I think it's highlighted the sort of shared challenges, and creative is the word to come up. And I think that's absolutely true, and innovative strategies that have been employed across these regional and international systems. I think there's lots of interesting things that have come up. Just to flag a few that I think have been particularly important, and that is to ensure that the victims remain central in any strategy around implementation, whether that is at the start in terms of drafting reparations requirements, but also subsequently, that their voice is heard at the national and international level, and they have consistent participation in any implementation processes. I think the other thing that's many things that have come up, but one of the other things that's been interesting is around the information available on implementation. These decisions are not always known, even among those that you would presume would know. But as Michael was saying, they can get hidden within one ministry with one person, and the system's not necessarily in place for communicating those decisions across those actors who need to know, not just within government, but elsewhere. So this is sometimes, and then beyond that, information about what measures have been taken by the state, again, is not always known. There isn't always a mechanism at the national or international levels to capture and make visible that information. And that's important for accountability, not only in terms of acknowledging what the state may have done and making that clear, but also holding them to account where things have not been done. And I know there's various attempts at play now at the African Commission to try and increase that visibility. And lastly, I think, what also has come out today is the positivity that there are examples of implementation. That sometimes you think things are not happening, but actually there are. We don't always see them And I think that the examples that have been given today do illustrate that and do push towards the need for sharing nationally across different sort of mechanisms and international and regional mechanisms in the countries, but also across the region. And I think that this event today has very much contributed to that. So thank you so much. I'm going to hand back to Alejandro for conclusion.
Thank you so much again to all the panelists, and especially thank you so much to Rachel for facilitating this discussion and everyone who joined us today. I think it was a really enriching conversation. So also from Redress, we would like to invite you to the next webinar on the Redress Solidarity Program on implementation of the survivor-centered approach principles. That is going to take place in November. We will share with you more information soon. So we look forward to seeing you there, and welcome your feedback on the topics that you would like to see covered in future events. So thank you so much again, and see you next time.